Good morning, Las Vegas. This is Clark Feeley sitting in for Gordon Martinez today. He had to go out of town and take care of a little business. I don't know if you recall or were listening on Tuesday, but I was at the end of his show talking about a case that I had before the Las Vegas courts here in Las Vegas. And he was talking about a case with O.J. Simpson that kind of fascinated me. And I listened to that, and he put me on his show to tell him a little bit about what was going on in my case. I wanted to kind of carry on today and tell you a little bit more about that. There was a newspaper article in the Las Vegas Tribune yesterday on the front page regarding a situation where I had gone to court here because there was a thing that happened to me. We have a trust, two trusts actually, that were created in New Hampshire by my mother when she was alive, and that was to protect her beneficiaries so that she could more or less bequeath a home that was on Lake Winnipesaukee, New Hampshire. It's a very exclusive neighborhood. It's a beautiful, beautiful lake, one of the nicest in the world. And we were lucky enough that my dad bought a home over 50 years ago on those waters, and it had gone through a lot of appreciation over the years. And now the lake is, a lot of the properties around there are owned by very successful and some famous people. One of my neighbors you may have heard of was Mitt Romney, who ran for president. He lives there in Wolfboro, which is the town where the home was. And then we have neighbors like Bill Murray and others that are industrialists, like the boss of Black and Decker lives over there, and it goes on and on. American Express. One of the founders, Mr. Allen of Microsoft, lives there in Wolfboro. So it's quite a little thing in the summer. Of course, in the winter, you might not want to be hanging around there too much, as hardly anybody does. But in the summer, it's probably the most beautiful place to ever be in the summer. Anyways, we had a situation where my mother had made an amendment to her trust in 2003, and she simplified things. She had made the original trust in 1992. So in 2003, she made it very clear and very fair. In my opinion, she had two offspring, me and my sister. And she bequeathed that each of us split whatever's left over equally, 50-50. And we would serve as co-trustees. So I don't know what kind of trust you can get that's simpler or more fair than that. That's certainly the case. Anyways, my mother then suffered a really bad stroke about a year later after she did that amendment. And since that stroke, she suffered from Alzheimer's and dementia. And she just wasn't too capable of reasoning at that point. Which is a shame, but that's, happens to some people that have those strokes. But anyway, that's the way it is. Now, my sister had always depended upon my mother. She never got too far ahead in life, that's for sure. Anyway, she decided to take it upon herself and take advantage of the situation with her mother. And somehow she got my mother to sign a document making her, instead of co-trustee, sole trustee. Well, my sister wasn't capable of running her own life, let alone a trust or anything like that. It's totally out of her purview of any knowledge whatsoever. And my mother never, ever, ever would have done anything like that if she knew what she was doing. She just wasn't capable of reading anything at that point or understanding what she was being put through. So my sister did a very vicious, malicious thing by taking advantage of an elderly woman that was sick in that capacity and took advantage of the situation. Now, the trust laws and so forth in this country need to be looked at a little bit, because when you have a piece of paper, it means everything. And that made a very bad situation for me, because I knew her. I knew she wasn't capable of being trustworthy and so forth. So I had a situation, and I didn't know anything about this new paperwork until my mother passed away. And then my sister shows up at a meeting, family meeting, and has this document saying she's the new sheriff in town. She's in charge of everything. Well, me and my oldest son knew that that couldn't be, because she just wasn't trustworthy. She was going to be ripping off money and doing whatever she could, and that's exactly what she did. Anyways, I had a problem because I couldn't get any records of what was going on because she was in control of everything by this paperwork that she had. So I would try to get documents. I told her she was sending out these things she was trying to pass off as legitimate bank records, which were anything but. They were things created on her own computer, and they were completely fraudulent documents. They weren't even right. I mean, they were hiding things. So anyways, I was forced to file a suit here in Nevada. Now, the suit that I filed was for records, and I had to have access to the bank to find out what was going on with the accounts and so forth. When my mother died, my sister immediately went to New Hampshire, cleaned out all my mother's trust accounts and brought them to Nevada, and she deposited in her bank, the bank that she uses for a personal account. So now she had trust accounts in that bank and a personal account. And come to find out, when I finally got access to the records, took me 2 years, by the way, I could see clearly that on a daily basis, she was just transferring money. When her account got low, she transferred money from the trust account right into her account, sometimes 3 times in the same day. So she was just using my mother's money, a trust money, which was half my money, as her personal piggy bank, and not giving me anything as far as what was going on except fraudulent documents that she was making up at home and passing it off as banking records. I mean, come on, I wasn't born yesterday. But anyways, so I was forced to file suit here in Nevada. Now, these are New Hampshire trusts, okay? Trust laws are that every state has their own sovereignty as it goes to trust law, and they create their own in hopes that people will create trust within their borders, and that helps them and creates jobs and so forth. So it's very productive for states to do this, and they compete with one another when they do it. Now, Nevada is supposed to be one of the top trust creating destinations here in the country. They have very, progressive laws that are good for the creators of the trust. And I think they're listed either 1, 2, or 3 at the top of the list of good places to have a trust. But anyways, I was forced to file a case here because she had moved the bank money here, and the records were here in Nevada. They weren't in New Hampshire, so I couldn't do anything in New Hampshire because they didn't have any records. So I had to file a case here in Nevada, which I did. Now, she continued to refuse to give up any records or what have you. She just was refusing courts to giving her orders to, release the records. And then she hired some lawyer named Howard Reitman, who was really an ambulance chaser and type of guy that never had a case like this before in his life. My sister was listed as a trustee. Well, any lawyer can go to Google and look up the address of his home on Lake Winnipesaukee, and he probably went, holy smokes, this house is worth millions of dollars. Oh man, if I hit pay dirt here. So he took my sister on as a client without any money. He never asked for a retainer. Well, she never had 2 quarters to pay him anyways. So he takes this case with no money. And now he is telling his client, well, you have to come up with the bank records because the court needs them and you have to give them to the court. And she refused to do so and refused to do so and refused to do so. Well, shortly thereafter, the lawyer's going, holy smokes, I got a problem here because it indicates that my client's hiding something, and that's not going to be good. And I have to get paid in this case, so what am I going to do here? So he goes to the court and he files a motion, and he requests that the case against my sister be dismissed because I made a fatal mistake when I filed the case because I didn't include the trust, and I didn't include all the beneficiaries that are listed in my mother's will and so forth. Well, this wasn't a trust matter. This was a matter where I had to get access to records to find out what was going on. If I did get the records, I was sure that it was going to show that my sister was stealing money, which she was. And then I could go to New Hampshire once I had the records and determine what the heck was going on. Hold on, I've got a call here. We'll see if this is something for us. You're on the air with Radio Tribune. Number. Anyways, so this lawyer went to the judge. The judge was Alan Earl. He's since retired. lucky me, I got him on this case because actually he was a construction defect judge that would hear cases when these hotels are built here in Las Vegas for billions of dollars. At the end of the day, the contractors are usually still owed about 10%. And they would end up fighting with the owners to see what they do about that 10%. The owner would say, well, the glass window's not thick enough, the carpet's not right, the brick's not, blah, 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 whatever they do, trying to get out of paying that 10%, which can be a significant amount of money. So Earl had a job of straightening all this stuff out. That was his expertise, if you will. Now, the construction industry took a big turn downward in '07 because of the recession. And by the time that I filed my case in '09, his workload had been decreased significantly, and I guess he had some free time because he got assigned my case, which was just a simple case to try to get records on what was going on with trust bank accounts and so forth. And he had no experience whatsoever in any cases like this. He never handled anything like that. So when this lawyer goes to him and says, well, this case is fatally flawed because he didn't include the trust, well, the first thing any judge should have known was, well, you can't sue a trust. It's not an entity. It's a relationship between the trustee and the beneficiaries. It's not a legal entity in that respect. Trusts are property or assets that are held for somebody else. The title is actually held by the trustee. It's not his property. He's holding it for someone else. And the beneficiaries technically don't own anything. What it's called is they have a potential asset that's held in anticipation that eventually they might get something. But until they do, they don't own anything. Therefore, they can't be sued. You can't take away what they haven't gotten yet. And that's the whole principle behind trust. Well, this judge, I don't think he had a clue about what trust law was or what a trust was. Anyways, he tells my lawyer to add in or amend the complaint that I filed, which was just against my sister only. She's the only one that did anything. I'm not going to sue other people that didn't do anything, or I can't sue a trust. I wouldn't sue my own trust anyway. What are we talking about? So anyways, the judge orders my attorney to amend my complaint and add in the trust and add in all the beneficiaries that my sister had changed. When she changed this trust documents, she went all the way back to the original trust documents, which mentioned my children as sharing in the home and this and that. My mother changed all that in 2003 because she didn't really know what she'd done in 1992 in respects to that. And she decided in 2003 that it would be better to leave whatever my children ended up with to me, and whatever wanted had a daughter by then too. So she had a child then. So whatever she wanted to leave her child was up to her, and maybe the grandmother or the mother shouldn't interfere with that type of situation. So she just gave everything that she had equally to her two children, which is fair. So anyways, that's what she did, and that's the way it was supposed to be. But now this judge was ordering that we go back to the 1992 document that she originally made that included everybody in the ownership of the home. And so that included all my children. So now I'm supposed to be suing my children, according to this judge, and adding them into the complaint as defendants. And they did absolutely nothing wrong. They're not a thing wrong. They didn't do anything with this money. They didn't take the money from New Hampshire and use it as their piggy bank. So this whole thing was getting ridiculous. But anyways, that's what the judge ordered, so that's what we do. So my lawyer told the judge that he did not have subject matter jurisdiction to do that over in New Hampshire trust. He didn't have the authority. When I sued in district court as a complaint. I didn't sue in probate court because I knew that probate didn't matter in this case because these were New Hampshire trusts. And Nevada would have absolutely no jurisdiction over New Hampshire trust whatsoever. So this was a case for the district court so I could get access to records. Once I got the bank records, my plan was to go back to New Hampshire and present the documents that I got to the court back there, probate court. And they could make the determination by looking at the records. Well, my goodness, the trustee is just misappropriating funds left and right here. So they would remove her. I was listed in the trust documents as a successor trustee. So I would automatically become trustee if she was removed. And that's what I had planned on doing. Well, it took me 2 years to get these records. Now, part of that may have been my attorney trying to run up his bill by talking to banks back in New Hampshire. I kept telling him, we don't need the bank in New Hampshire. We need the bank in Nevada is where we need to concentrate. That's what we need of those records. And he would bill me for hours and hours and hours of talking to New Hampshire, sending subpoenas and whatnot and everything. All he was doing was running up the bill. But anyways, when we would have a court hearing or this or that over the trying to extend discovery because Wanda hadn't given up any records, we would have a hearing, and both sides, even the defense attorney, would tell the judge that the judge did not have subject matter jurisdiction over the trust. And even the defense attorney would tell the judge that he had no authority whatsoever to order an accounting of the trust. So, you know, you don't have any right for the records, he said to the judge on numerous occasions. And the judge, being Judge Earl, thinking he walked on water, would give some lectures now and then. I have enormous power as a so-and-so at District Court 19. I can do what I order those records. You know, but anyways, nothing happened and the records weren't produced. Finally, through subpoenas on my effort, through my attorney, we finally got Bank of America records sent to us. And lo and behold, gee, what do you know? Here come the transfers, right from the money account, right into her account, sometimes 3 times in the same day. Her account would get low, down to like a $5. Well, here comes $1,500 from the trust. Oh, on the same day, here's another $500. Oh, let's take another $300. Comes over into her account, and then she pays her house payment, her car payment. She pays for her cable bill, her phone bill, whatever other miscellaneous things she makes, and you can see her account start to check on down. Well, her account pretty quick would be a negative balance. And then, oh, here comes the money from the trust. Oh, here we go, there we go. Nice, feather it up again so I can pay my bills. And that's what those records conclusively show. Now, this case that I filed in the Nevada District Court should have had a hammer come down at some point in there when these records were exposed, because this is all I was suing for. I mean, I had the records now. I could go to New Hampshire with them, and I could get the court back there to remove my sister. Well, I did that. I went back to New Hampshire with the records. I go to the probate court, and sometimes I disclose things, which people say I was, stupid to do that, but I'm honest. So I told the court back there that I had filed a case in Nevada. That's why I had these records. That's how I had to obtain the records. So I was justifying why I had them. And I was going to ask the court through a petition to remove my sister as trustee. The court back there said, well, if you have a case in Nevada, you just have to wait till they make a ruling or whatever and remove the sister over there and leave us out of it, because we don't want to put on our pants and do anything. So, you have to take this up with Nevada where you filed the case. Now, that was wrong information, I find out later, because that's denying me my property rights. I mean, these are New Hampshire trusts, and the New Hampshire court has exclusive jurisdiction over subject matter of any trust in New Hampshire. That's their job. That's what they're selling. When they create a trust in New Hampshire, they're selling to you that they have sovereignty to protect your property and so forth that you put in right. So they were dramatically and very wrong in that. But I knew that I had a case against my sister, and I knew ultimately that she would have had me removed. This is an issue that's going to be settled sooner or later. So I go trotting back to Nevada, and now the case proceeds. Judge Earl won't lower the hammer, so we start the trial. Well, my sister gets on the stand, and she is devastated, I guess is the description I would use. She had no excuses for how the money showed up in her account. She would say, well, I don't remember. It was like 2 years ago. I don't remember what that was for, that particular transfer. So my lawyer would go, well, maybe this will help you and refresh your memory. In this instance, you took $1,500 from the trust account and you put it over here in your account. Now, your bank account shows a car payment to Volkswagen. or a payment to Volkswagen. What is that your car perhaps? Oh, well, yeah, well, does that refresh your memory that maybe you took $1,500 from the trust and paid for your car? Well, I don't really remember. I guess maybe I did, but I don't remember. I mean, she was just devastated on the stand. She looked like the moron that she really is. Well, anyways, at the end of her testimony, there was a meeting that went on in chambers, and I had always told my lawyer throughout this case, all you got to do is get my sister on the stand. Don't really worry about too much else, because once you get her in the stand, the whole thing's going to collapse. She's going to be shown for what she is. And anyways, that's what happened. And I figured that, the judge would see this and they would have a meeting. Well, that's what happened. They go into the back room, they have a meeting in the judge's office or whatever. My lawyer comes out and says, well, the judge has a tendency right now to say that this thing could be over, but it's up to you, and whatever we come to arrangement here to get this thing finished has to be some sort of a settlement or whatever. I said, well, that's fine. I'm out $100,000 in my legal fees at this point because of all the running around my bank my lawyer did, trying to get the information from the bank that should have been given to me. I had a right to that. I had to pay to get that information. So I'm entitled to my legal fees. So what's going on with that? Well, the judge won't decide anything on that until you tell him what you want to do. If you want to, settle this thing or whatever. I said, well, what's the judge going to do? What are you talking about? Well, he won't say anything until you tell him what you want to do. So I go, what in the world are you telling me? That I've got to say, oh yeah, just give the judge whatever the heck, up to him, whatever. What about my legal fee? Well, he won't say anything. So I go, whatever. He said, well, we'll continue the trial if that's what you want to do. So I said, what choice do I have? I've got to get a ruling. I mean, how can I get a ruling that she didn't do what she did? I mean, so anyways, here we go. So now the trial goes on. And because of my children's involvement now, 2 out of my 3 children, I guess were greedy or what have you, but they were all confused because my sister's lawyer was lying to them. He was telling them that he is going to make me pay for everything, that this is my fault, that I sued my sister and trying to take their rights away from that property and so forth and blah, blah, blah. So he was lying to my children, filling their head with mush and telling them that he's going to get me for millions of dollars in damages and this and that, and they can all split up that pie at the end of the day, that they're going to get me for all that money. So 2 of my kids were in left field. Now, fortunately, one of my children, the oldest one, my oldest boy, has a brain in his head, and he said, well, this is crazy, So he would never have anything to do with that lawyer Reutemann, and told him so. And so he was testifying on behalf of the plaintiff in this case, because he wouldn't go for any of that crap. But my youngest kids, they just were off in Neverland, and as a result of that, they actually got on the stand and they would distort facts and so forth because they were trying to, I guess, protect themselves, they thought, because they had been lied to so much. And this was all done in front of the judge, and I don't know, this judge must be used to some kind of construction people in his courtroom or something, because the judge couldn't see beyond his glasses, I don't think. I don't know what happened here because everything was obvious, and maybe I'm too close to it, I can see things, but my children got on the stand and just absolutely lied through their teeth and distorted facts and so forth, and it was really pretty discouraging. Anyways, the end of the day, we ended trial finally. Well, something else happened though. After my sister was on the stand and got devastated, her lawyer had not done anything yet, so he wanted money. And now he needed money because he saw the devastation of his client on the stand. It was over. She was done for, and he lost the case right then and there. She was guilty. That was proven. So he wanted to get paid. So he made a motion the next day in court, the beginning of the day. He asked Judge Earl to award him $100,000, or he was going to walk out of the case. He was done. He was finished. Unless he got paid, he was leaving. Now, if I was the judge, I would have said, have a nice day. Don't let the door hit your ass on the way out. But this judge, I don't know, I things he did was amazing. Anyways, so he said he can't do that. He can't award, he's not willing to award anything at this time. The plaintiff hasn't even rested their case yet. You put on no defense. I mean, this is not procedure. I can't do this. And then in the next breath almost, he says, well, he says, I'm not that far removed from that side of the courtroom. I used to be a lawyer, and I'm not gonna have any lawyers working in my court pro bono. So all of a sudden, the judge is some kind of collection agency. I don't know why he's concerned about the lawyer and his fees. That should have been between the lawyer and his client, not the judge. And even especially in the middle of a trial. So anyways, this judge illegally, really, he awards this lawyer $62,500. Now, where's this money going to come from? Well, my mother owned stock. It was held in trust. The stock was located in New Hampshire in a broker house there. So the physical presence of his stock is in New Hampshire. It's not in Nevada. It's in New Hampshire. This judge orders that the stock be sold so that he can pay a defense attorney in Nevada. Now, that's illegal. Anyways, my lawyer jumps up, starts objecting left and right about this whole thing. Of course, Judge Earl wouldn't have anything about it because that's what Judge Earl wanted to do. He was going to make sure that all the lawyers in his courtroom got paid. That way he'd have a nice reputation with the lawyers, I guess. The hell with the family of the beneficiary. What do they matter? They're not going to contribute to his campaign. So anyways, in my last attempt, my lawyer says, well, if you're going to award any money to the defense, you have to award the same amount of money to the plaintiff because my client's out over $100,000 as it is right now. So if you're going to start paying the defense, you're going to have to pay the plaintiff too. And this lawyer, this judge, this construction defect judge says, wow, there's not enough money left over to pay both. What a boy, I tell you what. He's in a good place right now. He's sitting on his couch at home, I guess, and he never should have been sitting on a bench with a ruling like that. Anyway, so he dictates that my mother's stock be sold so that this defense attorney can get paid $62,500, half of which is my money. Great. Anyways, that's what happens. Now, the sign that this judge just let out of the bag, if you will, was that these lawyers now had a blank check because the home was worth millions of dollars. Remember that. And this judge now is willing, apparently, to take assets from the trust and just liquidate them and give whatever the lawyers decided they want. You're going to get paid. So the lawyers, that's what they go on. So now this Reutemann character, the defense attorney, he gets to ask questions and so forth of the people on the stand. And he asked questions like I think he asked my oldest son, driving was an issue with my mother could drive or not anymore. So he asked my son a question like, if you were a bus driver, what kind of bus driver would you be? And my son's going, is there a question in there? So what are you talking about? All the questions that this Reutemann would ask, you had no clue what the question was. Even the judge would make comments saying, oh, I don't understand the question either. I mean, it was ridiculous. This guy was stringing this baby out because now he thought he was getting $350 an hour every hour that he spent in court. And this thing could go on as long as possible. He didn't care. Now, the judge would make comments now and then. The longer this goes on, the worse it gets for everybody. So he made a statement in court that if this trial didn't end, it started January 31st of 2012. If this case didn't end by May 11th, he was going to end it. He was going to lower the gavel, he was going to make a decision, and that would be it. Whether we were done or not, or whatever, didn't matter. Well, Reutemann, the defense attorney, makes a statement, like not 2 minutes later. All this is on CDs, by the way. The whole tape was recorded. The whole trial was recorded. And he says, within about 2 minutes, well, I don't have any problem. I could go till October with no problem at all. Sure, he thinks he's going to get paid. Let's milk this baby as far as we can go. And now the judge, after just making the statement that he was going to end it, he said, well, if it's all right, I guess it could go to the end of the year. Whatever. So he's completely made another flip-flop. He said he was not going to award the attorney any fees prematurely, and he did. And now he said he wasn't going to let the trial go back May 11th, and he did. This guy was completely out of control. He lost all control of his court because the lawyers now thought that they had a blank check. Now, my lawyer, of course, he sees all this going on, and I had discussions with him over his fees and so forth being outrageous because this case is going on so long. And the fact that they added in my kids and everything else completely distorted this case into oblivion. It muddied the water so much that there was no way out of this mess. So I told my lawyer, look, I'm done. You get your money from this defense attorney because he's extending this trial, and there's no reason to extend this trial. You have the judge rule and have him rule now and so forth. So my lawyer said, well, he's going to sit back and see what happens, because if Raymond over there is getting paid, maybe he'll get paid too. So he really stopped representing my best interest, and he was just going to sit around and see what this judge did. Well, long story short, at the end of the day, he gets the case for decision at the end of June. June 27th was the last day of trial. In the closing arguments, the defense attorney speaking, and the judge would keep interrupting with a question and so forth. And at one point, the judge asked the defense attorney, do you think that I have the authority to order the sale of that home in New Hampshire? Now, there were two trusts. One held just the home in New Hampshire. The other trust was a money trust, we called it. It held cash that my sister took from New Hampshire and deposited in her bank account, and it held stock that the judge saw fit to sell some of it to pay her defense attorney, which was illegal. But anyways, so he wanted to know if the defense attorney thought that he had the authority to sell the house. Now, the defense attorney, all through the trial, would make a statement that the judge did not have subject matter jurisdiction, as with my attorney. The judge was told this continuously. He was told this so much that in December, before the trial started at a hearing, he said that he was disinclined to hear any more discourse over jurisdiction, that he had it and that's all there was to it, and that's the end of it. I didn't want to hear any more about it. And then on other pages, when it did come up, because it still came up, he said he understood that he didn't have jurisdiction, but he was required to rule by New Hampshire law. That's the way he answered that he had to rule by New Hampshire law. Well, I guess that's why he asked this defense attorney if he thought he had authority to sell the home in New Hampshire. This defense attorney said absolutely not. He says that's by the Constitution of the United States and property rights and the sovereignty between states. The only state that can control property within their borders is the state that has the property in their borders. So Nevada can't control title in New Hampshire. It's not possible. That's what he told the judge. So anyways, the judge, that's it. The case is over. He takes the case for decision. This was in June, the end of June. By November rolls around, and my oldest boy, son, is going, Dad, what the hell? When is this judge going to make a decision? One is devastated. What is going on? And she technically is still the trustee, so she's still spending money, doing whatever out of the trust. So I said, well, I went back to New Hampshire, and they wouldn't do anything because of this case in Nevada. Well, the case is still not decided in Nevada, so I can't do anything in New Hampshire. They won't let me. But we got the brilliant idea, you know what, you're a beneficiary. You go back to New Hampshire and you make a petition as an interested party that you want my sister removed, your aunt removed as trustee. So he goes trotting off to New Hampshire, makes a petition, files it with the court, pays the money and so forth to remove my sister. Well, time goes on. The judge is still not doing anything. Now this case in New Hampshire is going to be heard the first part of May in 2013. Well, I guess there must have been discussions with the Judge Earl or whatever here between the lawyers. I don't know what happened, but all of a sudden the judge, after 11 months of doing nothing, decides on April 29th to make a ruling. Now keep in mind that May 2nd, it was something in New Hampshire. Hold on a second. Hello,
Hi.
This is Las Vegas
Todd
Tribune.
with the fulfillment department. Your wellness package.
Well, that's another one, but we get those here. Anyways, so the Judge Earl makes a ruling a couple days before New Hampshire was going to remove my sister as trustee. I think the judge didn't want to remove my sister and allow Aaron to be trustee because Aaron wasn't really before the court, and the judge would have no control over Aaron. So whatever, he didn't want that to happen. So he makes a ruling, and he orders in this ruling that my sister removed from trustee. So she was removed for cause because she was stealing money, and he appointed me as trustee. Now, he didn't have to do that because the minute he removed my sister, I was listed in the document, the trust documents, as a successor trustee. So I became trustee automatically by New Hampshire law. So anyways, he made me a trustee anyway. So he was following New Hampshire law, like he said he had to do. But now this judge goes off the rails. Now, he probably had never heard a case in his life, being the background of what he had with buildings and so forth, having been constructed in Nevada. He never had ruled on a case where the property was not in Nevada. So he rules that Royman, the defense attorney, had represented his client and these other defendants now that he added into the case. He was protecting their property rights because if they were removed as beneficiaries because of the invalid amendment that was made in 2008 that referred back to the original documents, that they would be, whatever. So this guy Reutemann was defending them, which is a lie. It's completely not the case at all. And the judge is the one that added these people into the case. So this defense attorney wasn't representing them in their best interest because the defense attorney is only interested in getting paid. And as it comes out, he wants to get paid from the trust. Well, the trust is the beneficiary's trust, and the lawyer can't be paid from that because the trustees don't even own it yet. I mean, the beneficiaries don't even own it yet. So anyways, nobody's being properly represented. Here's my point. Anyways, in the ruling, the judge dictates that the losing defense attorney, he lost because his client was removed as trustee, and that's all they ever wanted. So the judge rules that the defense attorney arranged to get a broker in New Hampshire to list the New Hampshire property immediately and sell it for cash so that the money can be brought to Nevada and given to the court, and then he can immediately make a ruling as to legal fees. In other words, finalize his ruling and award fees, and then disperse the fees from the money right away to the lawyers, and that'll take care of that. And this thing will be all done and signed, sealed, and delivered. Well, I heard this, or I read that in the order, and I go to my lawyer, what in the hell is going on around here? This is totally, you can't do this. You can't sell a house in New Hampshire. And whatever, so of course my lawyer wanted to be paid, so he had stopped representing me too, in a way. So I said, this ain't gonna work. So I went back to New Hampshire right away. And as trustee, I sold the property. Now, I was born and raised in that neck of the woods. My dad bought that property in 1965. I was 15, 16 years old. But anyways, I lived on the lake every summer of my life since I could remember. And I knew everybody on the lake, and I knew a lot of very, very well-heeled people, if you will. Over time, that lake got to be something else. I mean, you'd have to be very wealthy to have a place unless you were lucky like us and just happened to buy it when it was for a song, and now it's appreciated so much. But all the new homes, everything that changed hands are all owned by multi-millionaires. Anyways, I knew a lot of people, so I went back to New Hampshire, and I had the property sold, signed, sealed, and delivered with the money in my pocket within a week. And this was during a time that, in the middle of a recession. No property had sold on the water for the millions of dollars that they were worth in over a year. Nobody had bought anything because these were all second, third, fourth, fifth, sixth type homes. The people that owned the homes didn't need the money, that's obvious, so nothing was selling. So I did a miracle. I actually sold the house. The lawyer, come to find out, was going to list the property for $1,200,000. They had it appraised for that. Now, I sold the property for $1,650,000. So I got over $450,000 more than they were even going to list the property for. Now, in a down market, you weren't going to get what you listed it for anyways, and these lawyers wouldn't care what the heck the property sold, as long as their fees got covered. They didn't care if there was anything left over for the Feeleys or not. The hell with them. So the judge even made a comment in the hearing that the lawyers are going to be paid first, and the Feeleys can have whatever's left over after the lawyers are paid. I mean, this judge is out of it. So anyways, nobody cared about the beneficiaries. And the judge never even thought that, wait a minute, the beneficiaries don't own anything yet either. He didn't know trust law. So anyways, I sold the property. This judge back here is going crazy. I come back to Nevada after I sold the house. And the defense attorney's going bananas because how is he going to sell the house and get paid? The house has been sold, they don't have the money. So the judge, they have an emergency hearing, and they contemplated in the hearing. The judge threw out what he had contemplated, that the home be sold, that the money be brought to his control in Nevada, and then he'll make a final ruling and award attorney fees, and then he would immediately distribute the money to the lawyers. That was his plan. Well, I stepped in his plan. Whoa. So he made a ruling. He removed me as trustee, or not right then and there. That happened a few days later. But he instructed me to turn the money over to him. And as a trustee of a New Hampshire trust, I have an obligation to protect the trust for the beneficiaries. That's my obligation, and no court has anything to do really with a trust. If you look at the law, any action from any court has nothing to do against the trust. You can't award money from a trust that's held in trust. It can't be done. So I go, so I immediately go back to New Hampshire, and I talked to the bank where I deposited the money, and I told the bank manager, I told him what was going on. He already knew what was happening because I told him why I was selling the house, because he couldn't believe I was selling the house. I never wanted to. So anyways, I told him what was going on. And I said, give me the money in cash, because this judge is just keep going off the rails. They're talking about an FBI investigation. They're going to check into the sale. They're going to overturn the sale. So anyways, he said, I don't think you want to walk around with $1.5 million in cash. He said, just get a cashier's check. That's as good as cash equivalent. We can't stop payment on it. We can't, as long as you have the check, you have the money. And the courts can't do anything about it because you got the money. So I go, all right, so give me a cashier's check. And that's what he did. So I got a cashier's check. Well, judge finds this out, goes nuts, and Reutemann running around going crazy. How's he going to get paid? And they're having emergency hearings continuously in court. And in the hearing shortly after I got the cashier's check, the judge removes me as trustee and finds me in contempt of court, issues a bench warrant for my arrest, instructs Reutemann to find out from the Homeland Security if they can remove my passport so I can't leave the country. And then he appoints a CPA here in Nevada as a buddy of his, I guess, to be in charge of the trust, supposedly. Now, keep in mind, this judge has no jurisdiction to do any of this. He can't do any of it. So he appoints a trustee that really has no authority other than this from judge, and the judge doesn't have authority himself. So anyways, this is really getting to be a circus. But I have the cashier's check, and I'm not in Nevada, so they can't find me. And I'm waiting for the judge to make a final ruling. Make a ruling. Whatever you're going to do, do it. And that way I can appeal it. So he knew I was going to do that, so he was refusing to make a ruling until he got this money somehow. So Howard Reutemann, the defense attorney, hires a lawyer in New Hampshire to somehow help them steal this money from the bank in New Hampshire somehow, because I had not cashed the check. I was holding on to the check waiting for a ruling. So the lawyer that he hires back in New Hampshire actually works for the firm that created my mother's trust. Now, whoa, you talk about a conflict of interest. What the heck's going on here? Here's the firm that created my mother's trust to protect it. And now they're going to use the same firm to steal money from the trust, to send money to Nevada to pay these lawyers that aren't entitled to anything. What in the world is going on? This thing has spiraled to some level of, I don't know, it's coming from another planet. I don't know what's going on. Anyways, all this stuff that's being done, I know the law, I can read the law, it's pretty black and white, especially trust law, it's pretty understandable. So what in the world is going on? So I consult with some lawyers, and they tell me, well, they can't do what they're doing. I mean, they can't, but they have to make a ruling, because you can't appeal until there's something that you can appeal. He hasn't made the ruling, and the judge is refusing to rule, and knowing full well that I'm going to appeal it right away. So he's stalling, he's not making a final ruling, and now we have this lawyer in New Hampshire that's trying to get the money from the bank. So this lawyer, somehow, first of all, the bank tells them they can't stop payment on a cashier's check. which is what the bank manager told me. There's no way we can stop payment on a cashier's check. So they try things. They try a restraining order. They try all these stupid things from the court there in New Hampshire. But an order from a court is no value. You can't stop payment on a cashier's check because the minute the banker gave you that check, it's called cash equivalency. He could have paid you in cash, and the courts consider that cash equivalency. So any court order telling the bank not to pay the check, it's already been paid. It's cash, so that they have to honor that check. Now, the bank, after trying all these things and restraining orders and so forth, none of that's working. So the banker, I think the lawyer, I'm speculating, but the bank's attitude changed. Now, what caused it to change? A bank officer suggests that, well, the only way they can stop payment on a cashier's check is if it's lost, destroyed, or stolen. So this lawyer knew, oh, okay, well, that's fine. It's lost then. The banker goes, it's not lost. We know who has the check. The guy we gave the check to has the check. So they go, well, that doesn't, we have to get this money somehow. So I think the banker was given some envelope full of cash or something because his attitude changed, and he's now is formulating an agreement between the court in Nevada and the bank as an officer of the bank, and they're entering what they call a stipulation agreement, where they're claiming that the check is lost, destroyed, or stolen, and part of that stolen part of the description is that it's in the hands of somebody not amendable to service. So they're going, hey, now we got him because we can't find him. So he's not amendable to service, so we'll use that. So anyways, that's what they project. But you got to remember, folks, I'm the trustee of this bank by law. New Hampshire law makes me the trustee because I'm mentioned in the document. Now, as trustee, I have every right to have that check. I'm the one that got the check. I'm the one that gave the money to the bank to get the check. And I am also a primary beneficiary in this trust. So I have every single right that anyone could possibly have to have that check. It's not stolen. And it's not in the hands of someone not amendable to service because I'm before the Nevada court. I filed the case. So, and there is no case in New Hampshire because they wouldn't take the case. So there's no case that I'm not amendable to service. As a matter of fact, I'm waiting for this judge in Nevada to make a final ruling so I can immediately appeal it to the Supreme Court of Nevada. So that's bull. That's just a fiction that these lawyers were grasping at straws trying to get somebody to do something. Anyways, long story short, the banker officer signs this agreement, and the agreement is signed by Howard Royton, the defense attorney, who this Judge Earl made receiver somehow. Here again, without authority or jurisdiction, he makes him in charge of getting the money. So Royton signs the check. Now, it's interesting to note here that the trustee that the Judge Earl appointed to serve as trustee in Nevada refused to sign the check. This guy is a CPA, and he knew that you can't stop payment on a cashier's check. So he didn't want to be liable for anything, so he refused to sign anything. So he wouldn't sign this deal. So the only people that signed it were Howard Royton, the losing defense attorney, and this banker. So and what they stipulated to was basically, and this really gets weird, there's language in there that it's called actually what it is. If you're going to pay a check that you've already issued, a cashier's check, you're going to stop paying, you're going to pay it again. You want to cover yourself as a bank has a liability to their stockholders and so forth, that they protect themselves. So they get what's called an indemnity agreement, to where if the check is claimed to be lost, and lo and behold, it's not lost, and somebody that presents a check that's entitled to payment has to be paid, the bank has to pay the check, then the person that signed the affidavit saying that the check was lost is liable for payment, so they have to pay the bank back for the second payment. Well, that's what this agreement says. But these lawyers and everything, they indemnified everybody. They indemnified themselves from liability. They indemnified this trustee that wouldn't even sign the check. I'd signed the agreement. They indemnified everybody except me. If you want to go after Clark Feeley, you go after him, but don't go after us. Now, what banker would accept this? That banker was paid off because no banker would go, this is garbage. What the heck is this anyway? He signed, the banker signs the agreement, and in it says it holds the trust liable. If they have to pay the check again, the bank's going to hold the trust liable. Now, the check's made out to the trust. The bank is going to be ordered to pay the check. So they pay it to the trust. Now the bank thinks they're going to turn around and charge the trust for paying the check to the trust. Kindergarten students could have come up with a better agreement than this. Anyways, everybody signs it. Everybody knows the check's not lost. It's not stolen. It's not destroyed. Everybody knows who has the check. And Judge Earl, in his wisdom, signs an order dictating that Howard Reutemann signed the stipulation agreement so that the bank will send the money to Nevada. Well, that's what's done. Judge Earl signs a fraudulent agreement. That's bank fraud. The sitting judge in district court in Nevada signs a document, and doing so, he commits bank fraud. That's a great judge, okay? And anyways, the lawyer back in New Hampshire and the lawyers and everybody and the judge in Nevada also induced the bank, interfering with a binding commitment that the bank has to pay this check. The other issue is nobody could sign an affidavit about a lost, destroyed, or stolen check otherwise, other than the last person that had the check. I'm the only one that's ever had the check. The check is not lost. It's not lost, never has been lost, and the only person that can sign for that check is me. That's it. And just to show you, I will show you the check. There it is. Made out $1,340,000 to the Martha E. Feeley Real Estate Trust. I have this check. I have always had this check. The banker gave me this check from his hand to my hand. Here is the check. Judge Earl says the check's stolen. Okay, lost, destroyed, whatever. It's a fraudulent, it's bank fraud is what it is. That's a felony. And the penalty for that felony is 30 years and up to 30 years in jail and $1 million fine. Now that's under 1344 of the U.S. Code. 1014 is inducing a bank to not pay a check. The inducement is the crime. Whether the bank pays a check or doesn't pay the check, the fact that you ask is inducement. The fact that you create a scheme under bank fraud and submit a fraudulent document to the bank, that's a scheme. The law is the scheme. Once you get together and you create a scheme, whether you're successful or not, the law is under the federal government that you created the crime by doing the scheme. So we have a district court judge here in Nevada that has broken the law, a federal felony. And he's sitting on the bench, or was till he retired. Anyways, long story short, they enter this agreement and the bank actually sends $1,340,000 to Nevada. Boy. Now, Judge Earl gets his money so he can pay his potential campaign contributors. So he pays Reutemann, he distributes over $500,000 immediately. He tells this trustee, friend of his, pay this immediately before the end of the year. They got the check sometime in December, and the judge wanted this dispersed before the end of the year. So that's what was done. Judge Earl, again, signs a document, an order, that's an invalid order. Now, the law is if you sign an order that doesn't have jurisdiction, subject matter jurisdiction, that order is void. Now, there's several types of things. There's an order that may be voidable. A voidable order, you can go to court and you can say, make this order void because it's voidable. This order, because he didn't have subject matter jurisdiction, is void. It doesn't have to be declared voidable, it's void. So that was another illegal document because he didn't have subject matter jurisdiction. So by the fact that he's ordering disbursements of money that was illegally obtained, this judge now is adding on to his crimes. He's creating what's called 18 U.S.C. 1957, which is kind of a money laundering type code, but it falls to anything that's obtained illegally, any money that's fraudulently obtained, and you order a disbursement of it or whatever, you're violating the 1957 law. That's another 30-year potential sentence and another $1 million. So this judge is stacking up these offenses. Now, when push comes to shove, the bank finds out that, whoa, they got to pay this check because they couldn't stop paying. The check is not lost. So there's problems here. Anyways, what's going to happen is that all this money's been dispersed. Now, Reutemann, the defense attorney, has since died. Last September, he decided to get out of town permanently, so he's dead. So he got over about $400,000 out of this money that was sent here from this bank. And all this money, when push comes to shove, I predict is going to have to go back to the bank. The bank has a case here. And who's going to be left holding the bag? As usual, the taxpayers in Nevada, because who's going to pay? Not Judge Earl sitting on his couch. He ain't going to pay. He's liable, and he's personally responsible because he lost his immunity. When a sitting judge breaks federal law, you lose your immunity. He can be federally prosecuted over this stuff. But who's going to pay? The state of Nevada is going to pay because he was a sitting judge. And that means that taxpayers of this fine state are going to be on the hook for over $1 million. It's about $1.8 million right now, counting interest and expenses and fees and so forth. I mean, this is ridiculous. This was a judge who did not have a clue what he was doing. And when he ordered that this complaint that I originally filed against my sister individually was changed to add people that were innocent. How can you add innocent people to a case? As a judge saying, why they didn't do it, but you got to add them into the case. I mean, what this judge, this court system in Nevada is crazy. It's insane. Anyways, this judge spiraled out of control. Then he awards Reutemann in the middle of a trial after my sister was on the stand and got devastated. He decides to pay him $62,500 because he used to be a lawyer, and he's not going to have any lawyers working in his court free, pro bono. So, I mean, whether it's legal or not, this judge doesn't care if it's legal or not. He doesn't care. Now, in September of 22nd of 2014, the lawyers in their wisdom decide, well, we got to file some more legal fees. The judge in his order decided to reserve from this money that was sent to him. He already distributed $500,000 to the lawyers, but he's going to reserve $400,000 for future legal fees in case Clark Feeley appeals this case. What? This judge has no bounds. He's going to reserve now for his fellow lawyers who are maybe, if he decided to run again for judge, which at some point he decided not to, but anyways, that's potential campaign contributors. So you have to feather up the lawyers that practice in front of you so they can support your campaign. That's what makes the justice system in this state is broken, severely broken. It's been hijacked by lawyers in conjunction with the judges, and there's a lot of issues here, and this is one of them. And the taxpayers are going to have to pick up the tab on this, and the taxpayers need to make some changes around here. You got to get on the warpath, and you got to say that this type of stuff is going to stop. But anyways, the judge, they have this hearing. The lawyers are asking for more fees. I go to court. Now, the judge is trying to throw me in jail. I show up in court. Now, everybody's running around. What the heck is he doing here? Oh, my God, So they're having meetings in the back room and bailiffs and everything. They're wondering, what in the world is he doing here? Anyways, long story short, I go out. I strenuously oppose what the judge is doing. And Judge Earl actually lets me talk for about 30 minutes. And I told him every single thing, every law that he's broken, everything that he's done wrong. And then Judge Earl, in his wisdom, rules in the favor of the lawyers, his buddy, and pays him another $30,000 out of my money. Well, how are you paying a losing defense attorney? Would you tell me? I don't get it. Anyway, so he does that. Now he's off the bench. Come last January. He's home on his couch or wherever he is. And now there's another judge named William Gephardt that shows up on the scene. Now he's running Department 19. Well, the lawyers, Reutemann died, okay? The defense attorney died. He's gonzo. So there's a lawyer named Mitch Kobiega who is supposedly representing Reutemann's estate. He's the estate attorney. Well, but there's like $600,000 sitting in the bank over here, reserved for lawyer fees. Well, I might as well get some of that. I know I had nothing to do with the case, but I'm going to put in for some legal fees because he's opposing my appeal. I appeal as soon as Judge Earl, he spent the money, he distributed it to the lawyer, then he files an order with the court on January 7th of 2014. He finally put a final order on the record. Now I could appeal. So I appealed it to the Supreme Court on January 22nd. So that's done. It's up for appeal. It hasn't been decided yet. But subject matter jurisdiction will be decided, and it has to be decided in my favor because the home wasn't in Nevada. It was in New Hampshire, in the case. So all that money's gonna have to come back. It's gonna have to come back from the taxpayers. So now Kobiega goes, oh, he's gonna file for some of this money, and it goes before Gephardt. And last Tuesday, a week ago this Tuesday, we had a hearing in front of his court. And Judge Gephardt, in his wisdom, gives me a lecture right off the bat when he first comes in. He tells me he's gonna, deny my request to stay. You gotta award these fees. Excuse me. Who's these lawyers? They don't have nothing to do with this case. And if they even did, they were losing attorneys. So they don't get paid. Well, the judge decided to give me a lecture. Hey, they have to be paid. They need their fees. They have to be paid. Well, no, losing attorneys don't have to be paid. This is a country. This country has a policy, unlike any other country in the world, where the loser pays lawsuits. Well, in this country, that's not the case. Each one's supposed to pay their own legal fees, but a court is supposed to never rule that the loser gets paid lawyer fees from the winner. I mean, I'm paying these fees. Why am I paying these fees? I won. I'm the prevailing party. I'm listed on the case as the prevailing party, and I'm listed as a judgment creditor. So I'm the winner. Here's a phone call. You're on the air with Vegas Tribune.
Hello.
Hello.
This is Darlene. I'm calling with Occupational Compliance and Safety Administration. I'm trying to reach the business owner or the business manager. Is either of them available?
No, they're not. Thanks. Bye. Sorry about that. The phone rings. You got to answer because we're calling in from outside to say something about this case. Anyways, my time's about up. We might continue this later. But anyways, Judge Gephardt, in his wisdom, decides to rule and award this lawyer who has nothing to do with the case, nothing whatsoever, award him $30,000. And who else are they paying? They keep paying the lawyer back in New Hampshire that is a felon because he broke the law by inducing the bank to send the money out here to Nevada. All these people have broken the laws, and the judge in Nevada continues to pay them. What is going on? This is illegal. The Supreme Court will rule that this is illegal, and this will all be straightened out. And guess who's going to pay? Taxpayers. You're going to be on the hook for this money. So you might want to get a hold of somebody to do whatever you can do and get a stop to this. Anyways, we'll take a break. Rolando might come on the air here shortly and do his show, and